When the topic recent trends in international institutional arbitration was coined for today's study series, we remember the words of the famous Greek philosopher Heraclitus, who said that there is nothing permanent except change, and also the words of George Bernard Shaw, progress is impossible without change, and those who cannot change their minds cannot change the world. In recent times, international institutional arbitration has noticeably morphed into a discursive topic of great concern as it is witnessing a monumental transformation as a result of global need for intensifying cost and time, quest for professionalism, innovation and want of diversity of arbitrators, and uniformity of awards and cost. Not to mention the growing needs of technology in the light of the present pandemic. Well-known international arbitration institutions have amended the rules in 2017 and again in 2019 to bring in the changes. A number of areas have undergone either small or considerable development in an attempt to make arbitration proceedings better tailored to parties' needs. Notable amongst them being the adoption of expedited arbitration proceedings and emergency arbitration by leading international arbitration institutes. It is evident from 2019 Arbitration Amendment Act that the focus of the Government of India is to make India a hub of institutional arbitration for both domestic and international arbitrations. Amendments were made to Arbitration and Conciliation Act 1996 by bringing in changes to subsection 6 to section 11 and also insertion of new sections 43A to 43M in the Arbitration and Conciliation Act 1996, which facilitates creation of Arbitration Council of India, which would not only grade arbitral institutions, but also take all necessary measures to promote and encourage ADR practices with a view to strengthen international arbitration in the country. It is in this above context that the topic, recent trends in international institutional arbitration, has a very great significance. We have with us today a prolific and versatile person in Mr. Ganesh Chandru, a skillful international arbitrator and advocate, partner Dua Associates, who has amazing grasp in the subject, a person of conspicuous ability with thorough knowledge of law, with a cheerful temperament. He is an accomplished speaker and will enliven the topic recent trends in international institutional arbitration. May I call a chairperson to introduce the speaker. Saranan, over to you.
Thank you, Mr. Ashok. Thank you, Mr. Anand, for your introductory note. Good evening and my warm wishes to one and all. The resource person for today's topic on the recent trends in international arbitration, international institutional arbitration is Mr. Ganesh Chandru. Ganesh Chandru specializes in international and domestic arbitration as well as commercial litigation. He is admitted to practice in India, England and Wales, and Singapore, and is a fellow of the Chartered Institute of Arbitrators, United Kingdom, and the Singapore Institute of Arbitrators. He is also an honorary overseas member of the Commercial Bar Association of England and Wales. Ganesh practice encompasses advising and representing parties in international arbitration matters and arbitration matters seated in India. He also advises and represents parties in litigation matters before the courts. Mr. Ganesh has handled cases arising from transactions relating to oil and gas, infrastructure, projects and construction, power, energy, telecom and IT sector, banking and finance, joint ventures, and general commercial matters. Prior to relocating to India in 2015, Ganesh spent more than 16 years in Singapore, during which time he worked with some of the top international law firms and Singapore law firms. Between 2002 and 2007, Ganesh was the counsel and assistant registrar of the Singapore International Arbitration Center, SIAC. Mr. Ganesh supervised the administration of about 500 arbitrations during his 5-year stint at SIAC, and also pioneered SIAC's initiatives in India. Ganesh also acts as an arbitrator and is a member of the panel of arbitrators of the SIAC, the Indian Council of Arbitration, the Nani Palkiwala Arbitration Center, and the Asian International Arbitration Center. He was an elected member of the Council of the Singapore Institute of Arbitrators from 2010 to 2014 and chaired some of its key committees. He has been recognized in the Global Arbitration Review 100 in 2019 as a significant name and has been listed as one of the future leaders by Who is Who Legal and the Global Arbitration Review London in the year 2017 and 2018 editions of Arbitration Future Leaders. Ganesh has been appointed by the President of the SIAC Court of the Arbitration as a member of the SIAC Users Council and by the President of the ICC International Court of Arbitration as a member of the ICC India Arbitration Group. In the cricket game, for a player, his own pitch matters a lot. After exploring the world in arbitration practice, Mr. Ganesh is now practicing from Chennai. Chennai is the home pitch for Mr. Ganesh. It goes without saying that Mr. Ganesh's performance in arbitration practice would be outstanding. I take this opportunity to wish Mr. Ganesh Chandru all the very best and request him to deliver his presentation. Thank you.
Thank you. Thank you so much, Saravanan, for that introduction. I'll just share the screen where I'm going to use a PowerPoint presentation. But before that, I would like to thank CNICA, Ashok, my good friend, Mr. Saravanan, Mr. Anand, for the kind invitation to be part of this wonderful series of webinars that they've been doing in these unprecedented times. He did mention that I've been back to my home pitch after almost 22 years. It's great to be back. One can take a person out of Madras, but you can't take Madras out of him. So I've always been, very much, though I've been away for some years, I've always been coming back, meeting all friends. So it's excellent. And I think CNICA is one of the leading arbitral institutions in South India. And of course, in due course, all India, it's going to become a very popular institution, especially with its new rules that was just launched earlier this month. I'll be covering a part of that as well in my talk. With these brief points, and thank you so much to everybody for logging in on a Friday afternoon. I'll just share my PowerPoint and then we can start the presentation. Are you able to see the screen?
Not a chance. Ganesh, once more, try once more.
Yeah, I'm sharing it. Yes, now?
Yes, now it is. Now, yes.
Okay, what I'm going to do, ladies and gentlemen, is I'm going to hide the video panel so that all of you can see the PowerPoint clearly. So in terms of questions, as Ashok had mentioned earlier, I'd be happy to take it at the end of the session. Okay, recent trends in international institutional arbitration. This is what is the topic. Already I think Anand has mentioned some of the facets of it, and this is what I propose to cover. Expedited procedure, emergency arbitrator, jointer of parties, multiple contracts and consolidation of arbitrations. I should tell you, ladies and gentlemen, that when you talk about recent trends in international institutional arbitration, as the topic suggests, I'm going to deal with a set of rules. So please bear with me. I hope to make it interesting. If it gets a little boring, I do have some anecdotes and some case laws and case studies, at least in the emergency arbitrator area, where there have been some interesting developments recently as well. But in addition to that, I'm just going to give a kind of the landscape of what these new rules are, which is extremely important in the armory of any arbitration practitioner in India and across the world as well. These are the trends that are very recent. So I would cover each of these in turn, and emergency arbitrator in a little more elaborate fashion because of the sheer number of cases that have been kind of referred under this particular rule to arbitral institutions. Expedited procedure is what I would start with. Many arbitral institutions in recent years have included expedited procedure in their rules for quicker resolution of the dispute. So if any client, I mean, many of you here I see are practitioners. If any client comes to you and they're going to say, we want to commence an arbitration, the first question they're going to ask you is, how much time is it going to take and how much is it going to cost? So everyone at the end of the day is bothered about how cost efficient the process is going to be, how quick are they able to resolve their dispute and get an order. You may be doing fantastic arguments and all that and quoting fantastic precedents, but at the end of the day, for the client, they need a result of the case. That's something which I think in India, it's very heartening to see about our amendments, which I'll be talking to you in shortly. But expedited procedure under institutional rules, some of the arbitral institutions that provide for it, I'm just giving you a few examples. There are a lot many which have these procedures. I'm going to talk a lot about SIAC, the Singapore International Arbitration Center, the ICC, which is the International Court of Arbitration of the International Chamber of Commerce. And in India, since it's a Sinica seminar, I thought it would be appropriate for me to point out about the Council for National and International Commercial Arbitration, which has amended its rules. The second edition has just come out on the 5th of October. And I would really recommend that all of you should go and take a look at these rules. And you should adopt institutional rules into your contract. That's extremely important. And I would say why. Let's take the SIAC rules, for instance. A party can apply for the expedited procedure to apply. If any of the criteria are satisfied, first, if the amount of dispute does not exceed 6 million Singapore dollars, 6 million Singapore dollars as of today's rate approximately is about, in Indian rupees, about 31.3 crores. So if the dispute does not exceed this amount, or if the parties expressly agree that they would want this expedited procedure to be applicable, or in case of exceptional urgency. So this application is to be made to the registrar of the arbitration center, and the party filing the application shall send a copy of the same to the other party, and it shall also tell the registrar that it has served the other side. That's extremely important. And then what happens when SIAC receives this application for expedited procedure? There's a Rule 5 which deals with it. And if under Rule 5.2, if the application is allowed by the President of SISC Court of Arbitration, the following procedures shall apply. When I talk about Court of Arbitration in the context of be it SIAC or ICC or the London Court of International Arbitration, is essentially a private set of individuals who have certain functions under the rules. This is nothing to do with the public court system. This is completely private. It's a court of arbitration, which is essentially a group of people. Some of the arbitral institutions do have a board of directors as well. SIAC has a board of directors as well as a court of arbitration. So the president of the SISC Court of Arbitration performs a lot of functions under the rules. And the president of the court feels that this is an apt case for the expedited procedure to apply. Then this is what will happen. The registrar may shorten the time limits under the rules. The case will typically be referred to a sole arbitrator unless the president decides otherwise. So most of it is sole arbitrator. Very rarely, unless the case is really huge, the stakes involved are large, and there are different nationalities and interests which need to be safeguarded, then perhaps the president may use his discretion to have a 3-man tribunal. But I mean, under this procedure, almost every case has been a sole arbitrator. The tribunal, of course, may, in consultation with the parties, decide that the dispute is to be decided on a documents-only basis, because once the arbitral tribunal is appointed, hearing will really be necessary only if there is examination of witnesses or if the parties feel that they really need an oral argument for the case. So the whole idea is to make this a quick dispute resolution process, and you can expect an award within 6 months from the date of constitution of the tribunal. Unless, of course, there are circumstances where you may need a little more time and the registrar can extend the time. So it's not cast in stone. So there are circumstances where the registrar extends the time of these 6 months. It's very important to note that the tribunal may state the reasons upon which the arbitrator, based on a summary form, unless the parties have agreed that no reasons are to be given. So if the parties decide it's a very straightforward case, I really don't need a very big reasoned award, I really need to get a quick resolution, they can go and tell the tribunal, see, we don't need a reasoned award, just give your award in a summary form. So that's a kind of option that the parties have. If the expedited rules apply, the procedure will apply irrespective of what the arbitration agreement between the parties is. So once it has been adopted, even if the agreement has certain other things which will talk about time limits and all that, this would be based on Rule 5. One other thing which is often we find in practice is that you agree to a certain procedure, right? But sometimes you don't realize that at the start that this is going to be this complicated. Let's imagine there's a case where you go to the expedited procedure tribunal and halfway through you think that this is going to be long-winded because of the nature of the case and because of a lot of witnesses and all that. Then you can always request the tribunal, and the tribunal may, in consultation with the registrar, order that the procedure will no longer apply, and the tribunal will decide the case as a normal SIAC arbitration rather than one under the expedited procedure. Just to give you some statistics on this, this particular provision was introduced by SIAC in the 2010 rules, and even in the 2016 rules it has found place. Until date, about 534 expedited procedure applications have been made to the Singapore Center, out of which almost 319 have been accepted. So this is a substantial kind of percentage where this procedure has been allowed. We have similar procedure under the ICC rules as well. Article 30 of the ICC rules 2017 read with Appendix 6 provides for this. An interesting thing in the ICC rules is that this procedure automatically will apply if the amount in dispute is not more than $2 million US, unless of course the parties opt out of it, or the ICC Court of Arbitration determines that it wouldn't be appropriate to apply this procedure for the particular case. So this is a very good thing for it to automatically apply. It need not be made by application. Parties can also agree for an expedited procedure irrespective of the amount of dispute. Even if the amount is much more amount in dispute, they can agree that this will apply. A sole arbitrator is usually appointed again here in the ICC. There should be the first case management conference within 15 days of the tribunal receiving the file. So this is very good. So within 2 weeks, you have your first preliminary hearing. And an award must be rendered within 6 months unless the time limit is extended by ICC court. You would see all these rules are quite similar. It's always mix and match here and there, except for a few, tweaking here and there. It's very good that institutions have now introduced this, because there are cases where you don't need to spend so much time on the case. So you can adopt this procedure, which is extremely good. Again, here, written submissions, written witness evidence, the tribunal can decide with the consultation of the parties to limit them. So you don't have too many submissions, you have brief submissions so that you get to the crux of the matter right away and not waste your time going round and round. And again, here the rule says that hearing can be conducted by a video conference, telephone, or similar means of communication. Of course, now most of the hearings, even normal arbitrations, are happening that way today because of the current situation. So you can do this. To let you all know, the 2017 of the ICC rules will be in force till December 31st, and from 1st of January next year, the ICC is coming up with a new set of rules, the ICC 2021 arbitration rules, which will take effect from the new year, 1st of January. There are very minor changes in terms of the expedited procedure. Is essentially the amount. So earlier it was 2 million, now it will be 3 million. But to be fair, this will apply only if the arbitration agreement is concluded after the rules come into force. So for all current arbitration agreements between 1st March 2017, when the earlier rules came into force, and the date till the new rules will come into force, it will still be 2 million. But if you have new agreements after 1st January next year, then the amount is increased to $3 million. I would also move to London Court of International Arbitration, which is one of the oldest arbitral institutions in the world. it was almost more than about, now it's about 120 years, and ICC is will be 100 in about 3 years time. So 1923 was ICC, and LCIA was almost 1899, if I'm not mistaken. This institution also has a procedure, but not for expedited procedure itself, but for expedited formation of the tribunal under the LCIA rules. You have Article 9A. Again, LCIA has a new set of rules which has just come into force on 1st of October 2020, about 4 days before our Seneca rules came into force. And here, party can apply for the LCIA for the expedited formation of the arbitral tribunal, and they can write to the registrar. And once this is done, the tribunal is very quickly appointed under the LCIA rules. Now, let me move to India. There are rules in India like the MCIA and ICA, which do have expedited procedure. But now I'm going to talk about something which is fresh out of the oven, Seneca rules. Rule 31 provides for expedited procedure. And here a party who has adopted these rules can, prior to the constitution of the tribunal, file an application to the Secretary General of Seneca for the proceedings to be conducted in accordance with the expedited procedure if the amount in dispute does not exceed Indian rupees 1 crore, or the parties have already agreed at the time of referring the dispute to adopt the expedited arbitration procedure. So here it is quite, very simple. If your dispute is within 1 crore, then you can go and write to Seneca asking for these rules to apply. Here again, the award shall be made within 6 months, and for the period of 3 months only at the discretion of the arbitral tribunal. It can be extended. Here again, there'll be a sole arbitrator unless the Secretary General decides otherwise. The similar provision, you can go for documents only arbitration, and oral hearing will be required if both the parties and the tribunal deem it necessary. Here it specifically says the final award should be a reasoned award because of the thing in India. In India, an award has to be reasoned. So it's very important for you to have reasons for the award. And by opting this procedure, the parties specifically agree for this procedure. Any provisions in the contract contrary to this will be overridden, right? And again, like the SIAC rules, here again, if the parties feel that halfway through, they feel that this procedure may not be suitable for the case, they can write in, and then this can be a normal Seneca arbitration rather than under the expedited rules. So arbitration at the end of the day is party autonomy. It needs to be a flexible procedure. It should not be something which, so you have decided you have to live with it. No, that's not the aim of arbitration. Party autonomy and flexibility is the cornerstone of arbitration. Okay, you may all ask me, hey, in India, we have institutional arbitration, yes, but I would think that at least 95 to 98% of the arbitration in India is ad hoc, isn't it? So much of ad hoc arbitration just under the Act, no rules of arbitral institution, adopted, but that is changing with the Sri Krishna Committee making a lot of recommendations and the Arbitration Act being amended. And the Arbitration Council of India, the provisions have come, it's yet to be notified, but hopefully it will in due course. So this is a new kind of an era we are living in, where hopefully in due course there'll be much more institutional arbitration in India rather than ad hoc. But what about ad hoc arbitration? Is there a provision? Yes. In 2015, the Arbitration Act was amended. And a new 29B was introduced, which provides for fast-track arbitration procedure. Here again, parties may, before at the time of appointment of tribunal, they can agree to have the disputes resolved by a fast-track procedure. And what would happen when this fast-track procedure has been adopted? The arbitral tribunal shall decide the dispute based on written pleadings, documents, and submissions filed by the parties without any hearing, unless the parties request or the arbitral tribunal considers a hearing necessary. The arbitral tribunal in the fast-track procedure under the Arbitration Act, they can dispense with any technical formalities if an oral hearing is held and adopt such procedure as they deem appropriate for the expeditious disposal of the case. Here again, the award shall be made within 6 months from the date the arbitral tribunal enters upon reference. In all other scenarios I spoke to you about, be it SIAC or ICC or CNICA, this time can be extended either by the tribunal or by the institution. But what happens in an ad hoc situation? Here I need to point out to you about Section 29A of our Arbitration Act, which in my view has changed the arbitration landscape in the country for the past few years. I was just kind of recalling recently in another discussion that the Niti Aayog conducted a very big conclave in Delhi, a very big international arbitration seminar at the Vigyan Bhavan in Delhi a few years back. And the then President, Shri Pranab Mukherjee, inaugurated it. Our Prime Minister, Mr. Narendra Modi, gave the valedictory address. And it was all, so much of support for arbitration. A lot of international arbitrators were there. They were all divided on this Section 29A of our Act. Many of them said this is a draconian provision. How can you, 29A, as it then read, said that an award has to be made within 12 months from the time the arbitral tribunal is constituted. Many of them felt, how can you do it when a case is very complicated? Of course, parties can agree for extension by way of consent for 6 months, and beyond that, you go to court for an extension of time. But some of the arbitrators did say, some of the international arbitrators said, this is very good for India. Please have some time limit, otherwise your arbitrations go on forever. But then when we look back, and now it's been 4 years, more than 4 years since this amendment came into force, and we see a complete change in the way arbitration is done in this country. So I think this has been a good provision in my view. And of course, now in 2019, this has been amended to give a little more of a breather to the parties and the tribunal. Now the 12 months will start applying only after the pleadings are closed. So it's not from the time the tribunal is appointed, but from the time pleadings are closed. You may ask me, hey, what happens if the pleadings go on forever? Not really. There's a provision in the Act which says that pleadings have to be completed within 6 months. So essentially, it's a 6 months extension, much more than what it was earlier. So 12 plus 6, you're talking about 18 for the arbitral process. Parties can agree for 6 months extension. So about you're looking at about, say, 24 months from the time the tribunal is appointed. If an extension is agreed by the parties, if not, it's 18 months. And you can still go to court for an extension of time. So this is for a normal arbitration. In case of fast track procedure, if within 6 months you cannot complete an arbitration, parties can agree under 29A. This will apply. Under 29B is the fast track procedure, but for extension, 29A provisions will apply. Parties can at the first instance agree for a 6 months extension. If not, you could still go to court. So this is the kind of landscape of the expedited procedure itself. We have seen institutions internationally, ICC in Paris, headquartered in Paris, which has a representative office now in Singapore. We have seen the Singapore International Arbitration Center. And to our friends, to just let you know, the maximum number of foreign parties at the SIAC are from India, and this has been going on for the last 10 years. So India is the maximum supplier of arbitration in the Singapore International Arbitration Center. So I think it's very important to know about SIAC, which is an Asian center. And next we have seen our own Indian center, the Center for National International Commercial Arbitration, where the provisions are. And we have seen what happens in an ad hoc scenario, which is prevalent mostly in India. So with that, I move on to the next topic, a very interesting topic, emergency arbitrator. Emergency arbitrator, as the name itself says, is somebody who is appointed on an urgent basis, right? Who is this emergency arbitrator? There are debates as to whether this is a misnomer. Is an emergency arbitrator an arbitrator? There are all these questions that raise. But this is a rather recent phenomenon. Okay. Typically, what you would do is you would go to the arbitral tribunal for interim relief, or till the time the arbitral tribunal appointed, you would go to court. For example, in India, you can go to court under Section 9 of the Arbitration Act for interim relief. But if a tribunal is appointed, now by law in India, you can't go to court under Section 9. You have to go to the tribunal under Section 17, unless you can show to the court that the tribunal will not give you an efficacious remedy. Only then the court will accept the application of the arbitral tribunal is in place. But what happens when you have an institutional arbitration where you've commenced the arbitration and you're looking at urgent interim relief even before the arbitral tribunal is appointed? This is what I'll be dealing with in this section of my talk. Some examples of institutions that provide for emergency arbitrage. In fact, the first center to have introduced it was the American Arbitration Association's international arm, which is called the International Center for Dispute Resolution. Then came the Stockholm Chamber of Commerce, Then SIAC introduced it, after which ICC introduced it, LCIA introduced it. In India, we have Indian Council of Arbitration, Mumbai Center for International Arbitration, we have that. Then CNICA also have these provisions in their new rules. So it's very interesting to note that in India, the 246th Law Commission of India, when it gave a report for amendments of the Arbitration Act, it recommended a particular amendment, and it said the definition of an arbitral tribunal under Section 2(1)(d) of our Arbitration Act should ensure that institutional rules which provide for emergency arbitrator are given statutory recognition. This is what was the recommendation by the Law Commission headed by Justice Shah. Arbitral tribunal means, and in the case of an arbitration conducted under the rules of an institution providing for appointment of an emergency arbitrator, includes such emergency arbitrator. So essentially, if we had taken this amendment on board, then there would be no issues, which I'll be pointing out later, on enforcement of the orders and or any decisions made by the emergency arbitrator. But fortunately or unfortunately, the Amendment Act of 2015 did not adopt these recommendations. Then after this, the high-level committee was appointed to review the institutional of arbitration mechanism in India, institutionalization of arbitration mechanism in India, which was chaired by Honorable Justice B.N. Srikrishna, a former Supreme Court judge. The committee submitted its report in July 2017, in which it also recommended, among other things, that the Act should be amended to enable recognition of awards made by the emergency arbitrator. This 2019 amendment, which followed the Sri Krishna recommendation, also did not take into account this recommendation. So today, by law, emergency arbitrator in India per se, on the face of it, is not recognized. I will now move to the SIAC rules. What I'm going to do here, my dear friends, is unlike expedited procedure where I took you through various institutional rules, for emergency arbitrator, I'll just stick to one particular institution, which has been very popular with Indian parties, so that I don't repeat, because the ICC rules or the Sinica rules or the LCI rules are rather similar when it comes to emergency arbitrator, except for one or two distinctions, which I will point out at the end. The SIAC rule says that a party may apply for appointment of an emergency arbitrator for purpose of grant of emergency interim relief. This application must be made concurrent or following the filing of a notice of arbitration, but before the arbitral tribunal is appointed. Under the 2016 SIAC rules, if the president of the Court of Arbitration of SIAC determines that this application should be accepted, he shall seek to appoint an emergency arbitrator within 1 day. You will get your emergency arbitrator within 1 day of receipt of the application by the registrar. Of course, you need to pay the administration fee and deposit. If you do that, you can get an arbitrator within 1 day, provided your application is allowed by the president of the SIAC court. If you look at the prior version of the SIAC rules, it was within 1 business day. So if it comes on a weekend, then you appoint on a Monday, but now it's not like that. Even if you apply on a Saturday, you'll get your emergency arbitrator on a Sunday. Right? The seat of the emergency interim relief will be the one agreed between the parties. Failing such agreement, the seat will be Singapore, without prejudice to the tribunal's power to determine the seat of arbitration under Rule 21 of the SIAC rules. Parties now have 2 days. You have 2 days if you want to challenge the appointment of emergency arbitrator. Challenge is usually done when there is justifiable doubts as to independent and impartiality of the arbitrator. Then you can certainly challenge the arbitrator under the SIAC rules, and then a decision will be made by the court if the arbitrator doesn't resign or parties don't agree for him to go. So it's not that they appoint somebody and there are justifiable doubts, then you can't challenge. Obviously, when SIAC appoints, they will ask the arbitrator to do a conflict of interest check, and they have to sign a statement that they are free and of all the parties, and sign a code of ethics before they are appointed. So they take utmost care about it. So do institutions in India as well. The emergency arbitrator, within 2 days of his appointment, should establish a schedule for consideration of the application. The powers vested in the tribunal, including the authority to rule on his own jurisdiction, will equally apply to an emergency arbitrator as well. The arbitrator in an emergency arbitration has the power to order or award any interim relief. that is deemed necessary. He shall give reasons for the decision in writing. That's very important. Please take note of this. There's a time limit of 14 days from the date of appointment for issue an interim order or award unless extended by the registrar in exceptional circumstances. So you're looking at 14 days time limit. There was no such time limit under the earlier rules. Now we have a very strict timeline. So within 2 weeks of the emergency arbitrator being appointed, you can expect to get an interim order. In most cases, it's much earlier as well, because if there's an emergency relief needed, then within 2 days schedule is, for which I will give you some practical examples. Okay, before that, I'll also give you a landscape of the Singapore International Arbitration Act, which is important. If you really need to know how much fees you need to pay for this under the SIAC rules, the emergency arbitrator's fees is about 25,000 Singapore dollars, and the expenses about 5,000. So totally you need to pay a deposit of $30,000 Singapore dollars to the registrar when you make this application, so that you can get your arbitrator right away. In 2010 was when this was introduced, and in the last about 9 years, if you look at the statistics of SIAC last year for annual report of 2019, 94 applications for emergency arbitrator and SIAC rules have been granted by SIAC. And if you ask me how many applications were made, it was 94 applications. So almost all, not almost, every application for emergency arbitrator has been granted. And of course, that's because SIAC is satisfied that there's an emergency there. Only then they will allow it. I would just like to point out Section 2(1) of the Singapore International Arbitration Act here for you, which was amended when all these emergency arbitrator provisions came. The definition of arbitral tribunal includes an emergency arbitrator appointed pursuant to the rules of arbitration agreed to or adopted by parties, including the rules of arbitration of an institution or organization. So by law in Singapore, emergency arbitrator is included within the definition of the arbitral tribunal, so there's no problem in enforcement there. This was what the Law Commission report, as well as Justice Sri Krishna Committee report, also recommended in India, but for their own reasons, I'm sure there's some reason why this has not been included. Probably in the next round of amendments, they'll probably consider this. We'll have to wait and watch that space. Now I move on to some practical examples I was going to give you. When this emergency arbitrator provisions was introduced in 2010, the first case came from India in SIAC. The claimant sought emergency relief by way of an injunction to restrain the respondent from invoking bank guarantees. SIAC received this application at about 9:30 p.m. in Singapore time on a weekday. Then SIAC appointed an arbitrator by 11:30 the following morning. So within 1 day of his appointment, the emergency arbitrator established a schedule for consideration of the application for emergency relief. According to the directed schedule, parties made written submissions and a hearing was conducted via telephone conference, and within a week for appointment, there is an interim order within a day thereafter. So you're looking at about 7-8 days within which the matter was kind of, the order was obtained. In the second case between an Indian party and a British Virgin Islands party, the claimant filed an application for emergency relief seeking an order restraining the respondent from breaching certain provisions of the contract. Within 20 hours, you had an emergency arbitrator in place. Within 2 days, a hearing was conducted. The emergency arbitrator issued an interim order within 3 days of his appointment. What I'm trying to say is this is a very, very quick process. And why has this been very popular with Indian parties? Generally in India, we always have a tendency to go to court under Section 9 for urgent interim reliefs. So perhaps that, and there's also judicial endorsement of SIAC emergency arbitrator provisions by the courts in India. So therefore, for example, in HSBC Holdings, Mauritius and Avital Post Studios Limited, the Bombay High Court, in exercise of its jurisdiction under Section 9, directed reliefs in terms of the awards made by the emergency arbitrator under SIAC rules. It was way back in 2014. There's a very interesting judgment. The Madras High Court as well in FSS and ICI World kind of endorsed the SIAC emergency arbitrator provision. So what I'm trying to say here is, though emergency arbitrator provisions are not directly enforceable because EA is not a tribunal yet in India. Once you get an order or an award from an emergency arbitrator in Singapore, you go to court and file a Section 9, and then this will have a persuasive value. It's been having a persuasive. I'm not saying in every case they do that. Look at this case, for example. In Raffles Design, the Delhi High Court held that the award of the emergency arbitrator was unenforceable under the Arbitration Act. It said recourse to Section 9 of the Act is not available for the purpose of enforcing the orders of the arbitral tribunal, but that does not mean that the court cannot independently apply its mind and grant interim relief in cases where it is warranted. So the court said that you cannot apply Section 9 for enforcement of these orders, but it said independently the court can still apply his mind and grant interim relief. And take it from me, when a court looks at a interim order from an international tribunal which has looked at the facts of the case, definitely there's going to be a lot of bearing on this court when it decides such an application under Section 9. So it's an excellent tool to go to the EA as well as come here under Section 9. You must have all heard of the movie Hotel Mumbai, which was based on the attack on the Taj Hotel in Bombay many years ago. And this movie, this is the case involving that cinema. It is between Plus Holdings and Zeitgeist Entertainment. It's a Bombay High Court case where the petitioner approached the Bombay High Court to restrain the respondents from releasing the film on over-the-top entertainment like Netflix platform in India on the grounds that it had the rights to release the film in the Indian market. The petition initiated proceedings against Zeitgeist in Singapore before SIAC. It had also done that. For reneging on its contractual obligations, the emergency arbitrator appointed in this case had restrained Zeitgeist from entering into any agreement or conferring any right on any person which may be inconsistent with or detrimental to the petitioner's rights set out in the agreement. So they had an emergency arbitrator order when they came to the Bombay High Court. The Bombay High Court, after considering the reliefs granted by the emergency arbitrator under the emergency award in favor of the petitioner, observed that there is some substance in the contentions raised on behalf of the petitioner. The court said that it appears that the right of the petitioner in regard to the film in question have been sufficiently recognized in the emergency award, although granted against Zeitgeist. In such a situation, Zeitgeist had had any right to be assigned in favor of Hotel Mumbai Private Limited, which was a special company floated for this, and whether can it be said that Zeitgeist would be legitimately entitled to any right of exhibition of film in question for the SAARC countries would be required to be considered. In the meantime, considering the facts and circumstances, the court held that it would be necessary to grant an ad interim protection to the petitioner till the adjourned date of hearing. Accordingly, this special vehicle company, Hotel Mumbai Private Limited, for restraint from entering into any agreement or creating any third-party rights in relation to the film Hotel Mumbai for the SAARC territories. Here, what happened was, this is exactly what I was telling you. There is an emergency arbitrator decision or an award that you have. Then you go to the Indian court. Ultimately, in this case, I think Netflix decided not to telecast Hotel Mumbai, and I think the movie was released in the theaters in November of last year. That's what happened. So this is a very, very interesting case. And again, out of the oven, just about 5 days back on 25th of October, when we were all celebrating Dashara, Ayudha Puja, the Singapore emergency arbitrator made a very interesting decision on the 25th, which was a Sunday, where emergency relief was granted to Amazon. You must have all heard about this very big deal that Reliance Retail Ventures Limited announced, that it entered into a deal for acquisition of assets and business of the Future Retail Group. Like big Future Retail Group deals with Big Bazaar, WH Smith and all that. So it's a huge group, and Reliance was supposed to acquire it for approximately 24,700 crores. So that's a very big kind of deal. Amazon approached SIAC over its dispute with Future Coupons because Amazon had invested about 1,400 crores into this business. And Amazon alleged before the SIAC tribunal, emergency arbitrator, and the main arbitration, and then you had emergency arbitrator, that the transaction was violative of the shareholders agreement between them and the Future Group. It cited breach of terms due to its sale of retail assets to Reliance. Amazon requested for an emergency arbitrator to be appointed where it sought interim stay on the merger so that future Reliance deal doesn't close formally while the matter is at the stage of international arbitration. The emergency arbitrator, after hearing the parties, granted interim stay on the deal on 25th of October, which is just a couple of days back. However, this has been done, but both Future Group as well as the Reliance Group are saying that they're going to go ahead with their deal because this doesn't really bind them. That's exactly the problem with an emergency arbitrator decision. Of course, I do not know till I do not know if during the court Amazon has filed any application before any of the courts under Section 9. Probably it might have filed it. I mean, I'm sure they will not. There's a chance that they would have filed it. But as of now, this is what is the position taken by Future Group. Now, this begs the question as to whether in India we need to really seriously look at amending our act to give teeth to emergency arbitrator provisions. It's not just because these international arbitral institutions have these provisions. Our Indian arbitral institutions have these provisions. The Indian Council of Arbitration has, MCIA, Mumbai Center has it. The Chennai, the Council for National and International Commercial Arbitration has it. So unless you have these provisions, it's going to be very difficult for you to enforce it, and you have one more round of litigation in court, which in my view will not be necessary if this is included within the definition, because straight away then you can enforce it as a order of court under Section 17, which has been amended in 2015, that orders of the tribunal can be enforced like orders of court. So I think this has to be done, in my view, to give efficacy to this emergency arbitrator provisions. So this brings me to the next topic. I mean, I hope I've given a flavor of expedited procedure and emergency arbitrator. Very quickly, the next two topics that I'm going to discuss is going to be very quick. One is on joinder of parties, and the other is on multiple contracts, which I will come to in a minute. Joinder of parties, again, I'll look at SIAC rules here. But before I move, I should say that the emergency arbitrator provisions in ICC as well as in LCI are quite similar to SIAC, except that in the ICC, the emergency arbitrator can only make an order. He cannot make an award. So they made it very clear it has to be an order. CNICA rules also has this provision. It's very progressive. In fact, the emergency arbitrator has to make his decision within 4 days. So that's very, very progressive, I would say. And here again, the emergency arbitrator can make only an order. So there is a significance if it's going to be an award. But then there's a question which will arise. There are debates which says whether an emergency arbitrators, even if you term it an award, is it an award? Because it has to be on a substance of a dispute. It has to be finality to a particular kind of issue in the matter. So whether it can be an award, or is it a misnomer, or should we only call it an order? SIAC, in fact, has taken up, they're going to amend their rules again, and there's a consultative process. Maybe this is one of the things they look at as well. So with that, I think, emergency arbitrator is a very interesting topic. We can go on about it, but then joinder of parties is another interesting aspect which I thought I should bring up, which has also been included in arbitral rules recently, because hitherto there was no such express provision in rules, but now you have such a provision. For example, in SIAC rules, a party or a non-party to the arbitration can file an application for joinder of one or more additional parties. They can file an application to the tribunal or registrar in case the tribunal is not appointed for joinder of parties, but provided the following criteria is satisfied. The additional party to be joined is prima facie bound by the arbitration agreement. All parties, including the additional party to be joined, have consented to the joinder. Once there's a consent, then there is no issue. They can be joined. And the SIC court or the arbitral tribunal, if appointed, would decide on a joinder application after hearing all the parties, including the additional party to be joined, and have regard to the circumstances of the case. In case there are disputes arising out of multiple contracts, so joinder is a very straightforward provision. I don't think I need to go into in much detail on that. So if they're prima facie bound, if parties agree, then the court decides, or the arbitral tribunal decide, SIC court or the arbitral tribunal would decide whether this particular party can be joined. It's very important in a lot of cases where if the relevant party is not a party to the arbitration, then even if you get an award, it will just be a paper award. So this is just to kind of facilitate that particular process. Multiple contracts and consolidation of arbitrations is extremely important here because especially in construction contracts where you have a main contract, subcontract, there may be multiple contracts which may be so much interconnected that you might want just one arbitration and one award out of all these issues, right? No point having different tribunals deciding different aspects. In case there are disputes arising out of connection with more than one contract, a claimant in such cases can file a notice of arbitration for each of those contracts as separate arbitration, or concurrently submit an application for consolidation under Rule 8, which I'll be discussing shortly. They can also file a single notice of arbitration in respect of all the agreements. You can do it either way. File separate arbitrations, ask for consolidation, or file a single notice putting everything together and still say that it must be considered for consolidation. The claimant just pays one filing fee in this case. Rule 8 permits process of consolidation of multiple arbitrations into a single process at two different stages, either before the constitution of the tribunal or after the constitution. However, the following criteria has to be satisfied. All parties should have agreed for the consolidation. All the claims in the arbitrations have to be made under the same arbitration agreement. And in case of the tribunal being constituted, the same tribunal has to be constituted in each of the arbitration, and no tribunal has been constituted in other arbitration. Essentially, what this means is that you don't want different tribunals for different arbitration because you don't want conflicting decisions. So it's best to have the same tribunal for all these arbitrations. And these agreements have to be compatible, and the disputes arising out of some legal relationship, arising out of contracts constituting of a principal contract and ancillary contracts, dispute arise out of same transaction or a series of transactions. We've had Supreme Court judgments in India dealing with this aspect as well. Where there's a mother contract and an ancillary contract, then it would, you can have, you can join the parties or have consolidations. In 2019, last year, 53 applications for consolidations were made, out of which 31 were granted. And between 2016 and 19, which is when the consolidation procedure was kind of made available, a total of 179 applications for consolidations has been made, out of which 105 has been granted. So this is just a statistics to give you a flavor of how useful these provisions are. In fact, you do have provisions for multiple parties, contract and consolidation in other rules as well, like ICC, and now in India you have in CNICA as well. So these are all very important recent trends, because no point having all this arbitral process and you can't get an emergency interim relief, for instance. So I guess this is what I wanted to cover today, and I thank you very much, and I would be very, very happy to take any questions later on, subject to, of course, I can now stop sharing so that we get the screen. Yeah, thank you so much.
Thank you, Chandru and Ganesh. We have a few questions in the chat. One question in the chat box, that is by Mr. Venkatesh and Ramakrishnan. He is asking whether joinder of parties is allowed in Indian arbitration.
Yes, it is allowed in Indian arbitration if you can prove that a party is a necessary party. Yeah. So you can do it in certain circumstances, yes.
Yes.
I would be happy to send you the case laws on this and you can forward it to him, Ashok.
Okay, fine, sure. We have one person, Ritika, is raising her hand. I'll unmute her. Yeah, you can ask your query now.
Hi, sir. Thank you for the session today. I had one question with respect to emergency arbitration. So in an earlier session conducted by Seneca itself, Ms. Hui, the CEO of SIAC, was the speaker, and she said that the biggest challenge was the appointment of the arbitrator itself, especially in terms of emergency arbitrations.
Yes.
So how do you think this situation can be tackled in India, considering the fewer number of well-known arbitrators, or will this not be an issue because there are fewer possibilities of going for emergency arbitrations itself?
That's a very, very good question. Thank you, Ritika, for raising that. Because in SIC, I do appreciate and know that it's been very difficult for them to get emergency arbitrator at a very short notice. But they've been very successful thus far because their panel is really, really big. And, they tap on resources, call people on their mobile, ask them to do a conflict check. Especially if the arbitrator works with a big law firm, he needs to do a conflict check. He can't just agree, that he or she will, be able to, come and do this in a very, very quick fashion. So I think that is really a challenge for SIAC itself, which is a very big panel. So when you're looking at India, you're very right in saying that we do have, I wouldn't say a shortage, but we do have panels of arbitrators, but then with the new amendments to the Act, now we have Schedule 5 and 7, which is, in fact, India is the first country that has adopted the IBA guidelines on conflict of interest in international arbitration. So I guess you'll have to look at all that. Then they'll have to say they are free and independent. So it's not going to be easy. And CNICA says it's going to appoint an arbitrator within 24 hours. So I think practical challenges are there. But I think if an institution, that's why I think that's why people want this institutionalization of the entire process. So if you have panels which have arbitrators who can, in fact, even in SIAC, if you look at the list of arbitrators, there'll be an asterisk next to most of them. If there's an asterisk, that means they agree to be approached for an emergency arbitrator appointment. But many of them will not put an asterisk because, for example, earlier I chose not to have that asterisk next to my name because I know that I'm working for a law firm and it's not going to be possible for me to very quickly get back to them to do a conflict of interest check within, let's say, 1 hour and say we are fine. So I think that's a real challenge. And I guess that's why we need a lot of independent arbitrators and younger arbitrators who can come forward, because now most arbitrations in India, we have retired judges who act as arbitrators, which is fantastic, which is excellent. But we have a lot of practitioners who are also developing as arbitrators. So I think that pool of arbitrators will be very useful in my view for emergency arbitrator matters. And young lawyers like you who will be coming into the profession and, soon, and law students who are going to be taking up law as a career and having arbitration as their area of practice, and other young lawyers, they should kind of, one good thing would be to tag along with some senior arbitrator, attend some be there arbitration, like your justice's law clerk, spend some time with a senior arbitrator, so that once you start practice, you can also offer yourself as an arbitrator, because it's easier if you have a big kind of a pool of arbitrators to choose from. And I think that these are great opportunities, I think, for young arbitrators in India. I would rather look at it very optimistically to say that, see, if you need something, let us say, and you don't have enough, you're going to choose from what you have, as long as they are able to deliver, right? So if you have a good trained set of young arbitrators who are ready to get into this, okay, emergency, it's a fantastic experience for them, and it's very quick. You don't need to sit and decide the whole case. They can use these younger arbitrators for the emergency arbitrator proceedings. But that said, it's also important for these young arbitrators to be trained, because these interim measures in emergency arbitrator can turn the table in a very big way. Like, for example, we've just seen the dispute between Amazon and Futures. A $3.3 billion deal has just been kind of not exactly stalled, but at least there's an order against it, right? So you must have some wisdom in the arbitrator as well. So that combination has to come. And I'm sure CNICA and institutions like CNICA can take it up, they're doing some excellent training programs like this. They can have, I would suggest that you have a specific program for training arbitrators who are between 5 to 10 years at the bar, lawyers, who will be a crop, very, very good crop for these kind of matters, I think.
Yeah, we are getting on with some training programs that is in line, which is going to come up. And one thing is, though the training will be given to arbitrators or lawyers who are looking forward for arbitration, appointment, we have a restriction because of the Schedule 5 and 7, 8,
Yes.
Schedule 8 restriction of
Yep.
10 years that we have.
Yes.
Okay.
Yes.
There's another question from Najib. He says, how will CIRB proceedings under IBC triggered before the NCLT and a moratorium declared affect international arbitrations?
Okay, there are several case laws on this. It's definitely, I would say that it depends on the kind of timing when you go and approach the NCLT for under IBC proceedings. In fact, one interesting case which I think all of us should read, because NCLT proceedings has become interesting. There are Indian Supreme Court judgments as well. One interesting case in the common law world, I would say, is Larsen Oil by Justice V.K. Raja when he was a judge of the Supreme Court of Singapore, which talks about pre-insolvency and matters that can go for arbitration, and whether once the insolvency commences, then it cannot. So, but when there's a moratorium, obviously you have a practical problem. There is a problem there. This is a topic in itself. I think Sinica did conduct a special seminar on this itself. So it's a practical issue which is not that easy. I can tell you that.
Ganesh, I have one query. You had explained how emergency arbitration and when it was created, it started off and all those things. Can you add something more to it? How did it really come up? Because the emergency arbitration was never existed until, say, about 4 or 5 years before. It all started recently, and it has been emerging as a very good option. And of course, as you said, there are issues of how we are going to enforce it. But how did it all start?
See, I think to be fair, I mean, the American Arbitration Association had it in its rules for quite some time,
Okay.
And it was nobody really bothered to look at it in a very big way. Then I think when SIAC amended its rules in 2010, I was in SIAC till 2007. And in fact, in 2007, there was a new set of rules. And then when it was amended in 2010, I think that kind of triggered, though Singapore and SIAC is rather a young institution. Once SIAC adopted it, in fact, it was perhaps the second or third after Stockholm, after ICDR AAA, Stockholm adopted it. And even then, Stockholm, it was not. But when SIAC adopted it, then it became extremely popular. And I think credit should be given to India for that. Indian parties for that, because they have used that provision so much that every other institution sort of, this is because, see, at the end of the day, arbitral institutions look at ways to reinvent themselves to be relevant. If you're going to offer the same thing all the time, then obviously people are going to say, okay, it's the same old. I mean, what else can you give us? What value add we can give us? And we can all, as lawyers, definitely agree that how much ever you go through a case, if you cannot preserve the assets or you cannot preserve the subject matter of the dispute, then there's no point going through the process, be it a civil suit or an arbitration. So I think there was a crying need for this, because the courts were overburdened with interim applications relating to arbitration. Even in Singapore, before the tribunal was appointed, they used to rush to court. So they were looking at how can you reduce this whole thing of rushing to court and have a quicker resolution by somebody and by people who are arbitrators rather than by judges. So who can appreciate interim measures in the context of arbitration in a commercial matter in a quicker way. So I think that's how it came about. And once SIAC adopted it, it became like a forest fire. Everybody around the world now has an emergency arbitrator provision in their rules. So I think we have to congratulate Asia to a great extent, and of course to AAA, who kind of conceived this idea. They are, I think they were the first at least till what I know, they were the first institution to come up with this kind of emergency arbitrator provision. And but I guess in ADR itself, we've had very much emergency, not emergency, very quick resolutions. If you look at the panchayat system and all that, they just sit under a tree and it's decided within 1 hour. So I mean, it's been there from time immemorial. It's just that we are kind of putting it in a kind of a proper form, in a proper forum, and making it practically useful for all the parties who come before. So it's not just you go for the normal arbitration, you get an interim measure, you have fast track. So all this together gives a very nice kind of a capsule for the parties who come before arbitral institutions. So these are good options in my view, so that it's user friendly as well. Of course, enforcement can be an issue in certain countries, but it has worked very well. It's worked extremely well till date.
How do you think the courts are going to react to this emergency arbitration? Especially, now what happens is during the arbitration proceedings, when we go under Section 9, they say you come here only on circumstances where an immediate remedy cannot be given by the court. Only then you come here. So now there is an emergency arbitration. When I go under Section 9, they're going to say, see, you have got an emergency arbitration proceeding. Why don't you go there? Why are you coming here? Will that be a lookout for the court?
Yes, I think you have hit the nail on the head. This can be an issue as well, because, for example, the only answer I can give a court, if a court asks me such question, is that I can say that you can't enforce an emergency arbitrator's order here in India. Therefore, the court has to give it. But we have had cases in India where you have an order by an emergency arbitrator outside India. So when you come back to India and enforce it, you can say that unless I file a Section 9, you are telling me there are judgments which says that I can't enforce it here. So I have to necessarily file an application under Section 9 to get to preserve the assets. So I think courts have been also looking at this carefully. I mean, all the courts know about this, and they are trying to help the parties as much as possible within the 4 ambits of the law. And there is certainly persuasive value of these decisions by emergency arbitrators.
I'll just find out if there is any further questions in the chat box. There isn't any. Okay. Friends, with this, that comes to the last session of thanking Mr. Ganesh for giving this wonderful speech. I think Saronan had started with saying that he is in his home pitch, and we cannot count how many number of sixes that he has gone by. Throughout the speeches, it's been all over sixes, and the boundaries could not be counted. That was I again thank Ganesh for immediately accepting our request to come and present to us. And the topic that we wanted him to talk was on international law. And he immediately came out with this particular topic, which was very relevant. And it so happened that his topic and the release of our CNICA rules coincided, and he was very kind enough to even include our rules and make his presentation on that. Thank you, Ganesh, for your presentation. And we also thank the participants who have been in large number. We'll meet in another 2 weeks' time with another speaker on another fresh topic. Until then, goodbye. Be safe. Take care.
Thank you so much, and wish you all in advance a very happy Diwali. Thank you.
Yeah, thank you. Thank you. Thank you.